the court decided 4 First Amendment cases last term, and in each case, the court found that the First Amendment had been violated in every single case. And the cases represented a broad array of First Amendment claims. One case, Fulton versus City of Philadelphia, was a free exercise of religion case. A second case, Americans for Prosperity versus Bonto, raised a freedom of association objection to a California regulation of charitable organizations. The third case was the first time in 14 years that the court addressed the free speech rights of public school students. And finally, the fourth case raised an Article 3 standing issue in the context of a free speech claim. I'm going to start with Fulton, the free exercise case, because the free exercise clause is an area where the court has been very active in recent years, and Fulton continues a trend in that area that's likely to continue into the future and that we'll see more of. So before I describe Fulton, I'm going to give a short version of the backdrop of this issue that includes both the establishment and the free exercise clause. So for some time now, the conservative members of the court have been trying to reduce the protections available under the Establishment Clause so that many fewer interactions between government and religion violate the Constitution under the Establishment Clause. At the same time, they've been expanding the protections of the Free Exercise Clause to provide increasing protection for religious liberty. So under both clauses, one central difficulty with the enterprise they've embarked on is the existence of a standard that has been used for many years. In analyzing Establishment Clause issues, it's the Lemon test, first announced in 1971 in a case called Lemon versus Kurtzman, in an opinion by Chief Justice Berger. And in free exercise clause cases, it's a standard introduced in an opinion by Justice Scalia in a case called Employment Division versus Smith, which was a 5-4 decision in 1990. And that decision uses a reasonableness standard in free exercise cases with some exceptions where strict scrutiny is used instead. And the Smith test only uses strict scrutiny if the law is either not neutral because it discriminates against religion, so it doesn't treat religion and non-religion equally, and also if the law is not generally applicable because it allows for exceptions in certain circumstances. Thus far, the conservative members of the court have been unable to agree on a test to replace either of these standards. When it comes to the Lemon test and the Establishment Clause, the justices instead have often ignored the test, or they've carved out some exceptions where the court focuses more on history and tradition rather than a precise test. 3 members of the current court, Kavanaugh, Gorsuch, and Thomas, have made clear that they would like to abandon the Lemon test entirely and believe it should be overruled. But even those 3 members of the court have not joined together to propose a substitute standard that would apply in all Establishment Clause cases. In the case of the Free Exercise Clause, once again, 3 members of the court, but this time a slight switch in the lineup. Justice Alito joins Thomas and Gorsuch, and they have argued that Smith should clearly be overruled. But other members of the court have expressed caution because they are less certain what should replace Smith. Instead, the justices have found it easier to conclude that the challenge practice is either not neutral or not generally applicable, so that it can apply strict scrutiny and require that the government show it has a compelling interest, and that exempting religious observers would undermine that interest, which is a standard that the government can rarely satisfy. Fulton involved a dispute between the City of Philadelphia and CSS, Catholic Social Services, over the placement of children with foster parents. Philadelphia enters into contracts with private social service agencies in which it pays those agencies to help the city to recruit, evaluate, train, certify potential foster parents, and then match foster children who are wards of the state with qualified foster parents. After the city learned that CSS refused to certify same-sex couples as foster parents, the department stopped making referrals to the agency, and later it refused to renew its contract with CSS, since as part of the renewal process, agencies have to certify they are complying with state regulations and terms set by the city, including non-discrimination requirements. After the city refused to renew its contract, CSS filed suit against the city, claiming that requiring that it place children with same-sex couples in violation of its religious beliefs that marriage should be between a man and a woman violated its rights under the Free Exercise Clause. Fulton reached a unanimous result in favor of Catholic social services, but on very narrow grounds. While the challengers once again, as has been true in some past cases, asked the court to reverse Smith, it didn't. Chief Justice Roberts wrote the majority opinion. It was joined by all of the members of the court except for Thomas, Alito, and Gorsuch, who concurred in the judgment. Alito, Gorsuch, and Barrett each wrote concurring opinions. To decide the case without overruling Smith, Chief Justice Roberts, in his relatively brief 15-page opinion, interpreted the city's contract with the private agencies to allow for individual exemptions, because there was a contract provision that gave a city official the sole discretion to create exceptions to the non-discrimination provision in the contract, thus creating a Smith exception because it wasn't a rule of general applicability. He reached that result despite the fact that the city had never once used the contract provision to create an exemption. He also quite quickly disposed of the argument that had been relied on by the courts below and also by the city that finding foster parents was a government function, and the city was contracting with CSS to assist in that effort. And while there are a series of cases that have held that the government has more authority to require compliance in the context, in that government contracting context, because the First Amendment rights of government contractors are more limited than when the government is regulating private conduct that isn't performed on behalf of the government. Roberts' opinion nevertheless rejected that argument, relying on the same ability to create exemptions as he had in deciding that strict scrutiny applied. And he also pointed out, I think quite interestingly, that the contractor cases all involved free speech, the past contractor cases, which is true, but not freedom of religion claims. So I gather that he's telling us that those claims don't have to abide by that carve out for government contractors, although he doesn't expressly say so. Roberts' opinion is brief, and it is a stark contrast to Justice Alito's 77-page concurring opinion, which spent most of its 77 pages criticizing Smith, but very little time discussing what would replace it. Both Alito and Gorsuch criticized the chief's reliance on the contract provision as the basis for deciding this case, because that provision, as they pointed out, could easily be removed when the city updated the contract, and therefore the entire basis for this decision would be removed as well, which they thought was inappropriate as a basis for the opinion, that narrow cast opinion. So while Fulton was in fact quite narrow, and it dealt with very much with the city's the specifics of the city's arrangement with the private agency, it once again shows the court bending Smith in favor of religion whenever it wants to. And while the court may eventually overrule Smith and possibly apply strict scrutiny to all free exercise cases, there's no urgency in reaching that issue now that the court can so easily carve out exceptions. So the second case that I'll discuss is Americans for Prosperity versus Bonto, which was a 6-3 decision with the 3 liberals dissenting, the only one of the 4 cases that had that more traditional lineup. The case was a successful challenge to a California requirement that charitable organizations have to disclose the names of their major donors so that California can police charitable misconduct. The court, in another opinion by Chief Justice Roberts, invalidated the requirement because the information the court concluded was not necessary for California's regulatory efforts. They had other ways to police misconduct. And while that description sounds like fairly conventional First Amendment reasoning, there are several important aspects to Americans for Prosperity. First, earlier cases relied on by the charities, beginning with NAACP versus Alabama in 1958, were all in the form of as-applied challenges, where the specific organization seeking relief had to prove that they and their members would be harmed in some way by some retaliation or threats made against them by the release of their members' names. If successful, the law couldn't be applied to the specific organizations challenging the law, but it could be applied to other organizations who had not made that same showing. In Americans for Prosperity, by contrast, the court struck down the California requirement on its face because it was substantially overbroad, since the court decided a significant number of its applications were unconstitutional. And as a result, the state can no longer apply it to any charitable organizations, even ones that can't show they or their donors will be harmed by turning the information over to the state. The court reached that result, even though the exact same information is already turned over to the IRS, and California was actually only asking for a copy of the federal tax form that the charity had already filed. Another quite controversial question raised by the court was the standard to be applied to disclosure requirements, whether strict scrutiny or a slightly less demanding standard, which is called exacting scrutiny. The part of the Chief Justice's opinion using exacting scrutiny was the only part where he didn't speak for a majority. In choosing that standard, the chief relied on a series of campaign finance cases, which applied exacting scrutiny to reporting and disclosure requirements, but unlike in this case, upheld those requirements. One of the few forms of campaign finance regulation the court has not struck down. By contrast, Justice Thomas, for example, concluded that strict scrutiny should apply to all disclosure requirements. And Justice Alito, joined by Justice Gorsuch, found it unnecessary to decide what standard should apply, since California's requirement failed even the exacting scrutiny standard. Justice Sotomayor's dissent in the case focused on the court's decision to assume that all disclosure requirements impose burdens on associational freedoms and strike down the requirement on its face. And she writes in her decision, I will find the quote in a minute. Today's analysis marks reporting and disclosure requirements with a bullseye. Regulated entities who wish to avoid their obligations can do so by vaguely waving towards First Amendment privacy concerns. It does not matter if not a single individual risks experiencing a single reprisal from disclosure, or if the vast majority of those affected would happily comply. and the suggestion she's making is that with this decision, it's much more likely that the court will reverse itself and strike down disclosure requirements, even in the campaign finance context, where those regulations have been upheld. So that brings me to the third case, which is the student speech case. Once again, some brief history. In 1969, in Tinker versus Des Moines Independent Community School District, the court, for the first time, addressed the issue of the free speech rights of public school students. And that case involved several students who came to school wearing black armbands to protest the Vietnam War. And the armbands violated a recently adopted school policy, while the court recognized that First Amendment rights of students don't stop at the schoolhouse gate, as the court said. The court allowed the school to discipline students for their speech under two circumstances. One is if the school could reasonably anticipate that the speech was likely to cause substantial disruption at school. And the second was if the speech caused actual substantial disruption at school. The court concluded that neither situation existed in Tinker, and therefore the discipline was impermissible and in violation of the First Amendment rights of the students. But after Tinker, the next three cases decided by the court carved out exceptions to the substantial disruption standard, where the school could much more easily impose restrictions on student speech. And for one example of this, if the student speech was engaged in as part of a school-sponsored expressive activity, for instance, writing an article for the official school newspaper, as part of a journalism class for credit, the school could censor the article if it could show it had a legitimate educational objective in doing so, a standard schools can almost always easily meet. The case this term was the first case involving student speech that didn't take place at school or as part of a school supervised activity, as well as its first effort to deal with student use of social media, since the case involved two Snapchat photos sent from a local store by a high school student to her friends, expressing her anger at not being selected for the varsity cheerleading squad. The images were sent to 250 friends, who included some people who were also students at her school, some of whom were also on the cheerleading squad. And one of the images had a profanity-filled caption. After a student who received the photos sent screenshots of the images to other squad members, and they were shown to cheerleading coaches, the student was suspended from the junior varsity squad, and she filed a lawsuit. The school argued that it could discipline students for conduct away from school if they could satisfy the Tinker substantial disruption standard, that essentially the same standard applied away from school as at school. The student argued, by contrast, that the school had no authority to discipline her for speech that occurred away from school, no matter what effect it had in school. The Supreme Court rejected both extreme positions, and instead they attempted anyway to choose a middle ground, although the decision left many questions, most questions, to be resolved in future cases. The vote was 8-1 in favor of the student, with Justice Breyer writing the majority opinion, joined by every member of the court except Justice Thomas, who was the lone dissenter. In addition, Justice Alito wrote a concurring opinion joined by Justice Gorsuch. The middle ground chosen by the court was to conclude that public schools could sometimes, but not always, discipline students for off-campus speech if they could satisfy the Tinker standard. Moreover, it decided that BL speech didn't fall into the category where school discipline was permitted by the First Amendment, although it's not exactly clear why that is. I've now described the only points of certainty in Justice Breyer's opinion. What was far from clear was how to distinguish between speech away from school that could be sanctioned by a school and speech that couldn't be sanctioned by the school, even if it caused substantial disruption at school. Justice Breyer identifies three factors, very general factors that restrict a public school's ability to impose discipline for speech away from school. They include the fact that off-campus speech will normally fall within the zone of parental responsibility, that students, while away from school, must be left with the ability to participate to some extent in the marketplace of ideas, and that is particularly true when they want to express unpopular political or religious views. And finally, that the school itself has an interest in protecting a student's off-campus unpopular expression, since America's public schools are nurseries of democracy. Or at least I would add, they used to be nurseries for democracy. What is very unclear, however, is what factors outweigh those three very general factors and allow a school to impose discipline. And those questions were left for another day, and it will be left to lower courts to struggle to answer those questions until the Supreme Court brings more clarity to the issue, whenever that should happen. The final First Amendment case, Uzubunum versus Przewski, was another 8-1 decision. This time, Justice Thomas wrote the majority opinion, and it was Chief Justice Roberts who was the sole dissenter. And this was, as it turns out, this was the first time in the over 16 years since Chief Justice Roberts joined the court where he was the lone dissenter. The case didn't decide any question about the merits of the First Amendment claim, but it resolved the issue of whether a request for nominal damages alone is a sufficient basis to preserve Article III standing. It was a lawsuit brought by two students at a public college in Georgia, and they were challenging school rules that limited the distribution of religious literature, as well as speaking about a student's religious views. And the students sued the college officials in charge of enforcing these restrictions on free speech grounds. In their lawsuit, they sought an injunction against the enforcement of the rules, as well as nominal damages. In their case, $1 was requested to reflect the fact that their constitutional rights have been violated. After the suit was filed, the college eliminated the restrictions. And it, of course, then asked the court to dismiss the case, since it was now moot because the policy was no longer in effect and the students had not requested compensatory damages. In response, the students argued that the case still presented a live controversy because they were entitled to nominal damages. The Supreme Court ruled in favor of the students, and Justice Thomas, in his opinion, reviews the elements of standing required by Article III, focusing on the question of whether the plaintiffs had requested a remedy likely to redress the denial of their constitutional right. Based on common law history and the conclusion that nominal damages can redress a past injury, even if no compensatory damages are requested, Justice Thomas concluded that the requirement of redressability was satisfied. In his dissent, the Chief Justice, as he frequently does, focused on the impact of the court's ruling on the federal courts as an institution. And in that regard, he writes in his opinion, if nominal damages can preserve a live controversy, then federal courts will be required to give advisory opinions whenever a plaintiff tacks on a request for $1, thereby turning judges into advice columnists. Because I would place a higher value on Article III, I respectfully dissent. So what should we make of this collection of First Amendment cases, other than the fact that the First Amendment scores a victory in each of the cases, although often with the court doing so in a cautious way, and also the fact that the divisions among the justices were actually more often among the conservative justices who didn't disagree about the outcome, but instead how to reach that outcome, rather than the more traditional conservative liberal divide. Well, I think beyond those two, the cases, while they represent a diversity of issues, have a common trend of conservative members of the court expanding First Amendment rights to strike down government regulations of various kinds, their own version of Lochnerizing. And this is a trend that Justice Kagan wrote about in a dissent in 2018. Where she described this as weaponizing the First Amendment. And I think this group of cases makes clear that the court's majority has no interest in ending or reversing this trend and is not laying down its First Amendment weapons anytime soon.